Hi everyone, welcome. I'm Karen Cole from Legal Minded Friends. I should sit up. And today we're going to talk about the act of deception. So the act of deception is when you're deliberately causing someone else to accept something as true, but it isn't true. And we're going to go through a few examples that I found in the Karen Reid trial. So let's get started. Oh, just a minute before we get started, I want to point out that I was on Joey Brooklyn's channel, so you can check that out. I'll leave a link in the chat section. And who knew this? You can go on to mentions on YouTube and you can see if someone's left a comment about you. And that is pretty special, as someone left a really nice comment when I was on Joey Brooklyn's channel. So thank you very much for that. I appreciate it. And I also want to give a big shout out to Michael's Adventures. We're coming up to, the holidays. I thought his videos are really relaxing. And look what you see. It's a little reindeer. Do you think it could be Rudolph? Who knows? Okay, now we'll get started for real. So let's just remind ourselves. Deception is the act of deliberately causing someone to accept something as true that isn't true. And could this be one of the biggest deception stories of all? Perpetuating the Santa Claus deception. So this is an article in Philosophy Now. This author wonders whether pretending there's a Santa Claus is naughty or nice. Every year, millions of parents tell children a big fat lie. There's someone called Santa Claus who lives at the North Pole with his wife and a bunch of elves who make toys all year long. And every Christmas Eve, Santa distributes toys to deserving children across the globe, with the aid of flying reindeer pulling a hefty sleigh. The parents know full well this story is false. Why are millions of parents being unethical every year? What gives? So if you're interested in the rest of this article, check it out. But basically, just a second. You can kind of see where he's going with this when he says, the rough idea is that we have an ethical obligation to form our beliefs in accordance with the best evidence. So this, really ties in with law, but does it tie in with make-believe? Well, it's quite interesting because believing the moon is made of blue cheese despite the mounting evidence to the contrary would violate the ethics of belief. For instance, it would be a strange world indeed if it were ethically permissible to believe whatever one wanted, despite strong evidence against the belief. So yeah, I think you should read that article. It's very interesting, and he might have something there. Now I'm going to play a clip of the Commonwealth prosecutor in the Karen Reid case address the court at the motions hearing. The Commonwealth prosecutor is trying to argue the judge should see the police body cam video of when Karen Reid was brought into the police station, and he says she made incriminating statements. Let's have a listen to that.
Oh, we don't have the screen up. Do you have it? I'd like to see exactly what it is that you intend to introduce. So this is your motion in limine to admit evidence that the defendant was in custody for a period of time after her arrest. Jim, is it possible for you to print that for me?
13.
Yes, please. Thank you. Okay. All right, I'll hear you on this, Mr. Lally, and remind me the date that this body cam footage was taken.
So, Your Honor, this is in reference to the defendant's arrest post-indictment by the grand jury in this case. So it's June 9th, 2022.
So that's why I have not seen the video itself.
Correct, and that's certainly something that the Commonwealth can provide for the court. But essentially, when she's arrested and during the booking process at the Milton State Police Barracks, the troopers who conducted that arrest were wearing a body-worn camera pursuant to their BWC policy with the state police. Council has a copy of the policy, council has a copy of the video, and essentially there are a number of different statements which provide sort of third, fourth, fifth, sixth, I'm not sure what number we're up to at this point, of sort of varying accounts that the defendant has provided to numerous people.
Can you give me an idea now? Do you know the substance?
So the substance of these particular statements is the defendant, Ms. Reed, continuously is told by Sergeant Bukhenik to essentially stop talking. He's advised her of her Miranda and advised her to stop making statements, and repeatedly states that to her during the course of her making statements. But the sum and substance of it is she says something to the effect of, you know, are you in on the joke? And then makes some sort of reference to having witnessed Brian Albert and Colin Albert essentially smashed John Okeefe's head into the taillight, indicating that that's how her taillight was broken. Doesn't make any sort of further statements about why she would then leave the scene after that occurred or anything like that. But these are, again, different accounts that have been made in direct variance to prior statements that she made January 29th to the troopers, to paramedics, to treating medical professionals, to Ms. Roberts, to Ms. McCabe, to the niece of Mr. Okeefe, to a whole other sort of slew and variety of people with a different sort of variation on what transpired each time. So it's sort of inextricably intertwined with the fact that she's in custody.
How so? Is she in handcuffs? Is she in a cell?
She's seated at the booking desk or the booking rail in the state police barracks. So, I mean, I don't need to make direct reference to it. It's just, again, it's something out of an abundance of caution based on sort of where it is and when it is that the statements are made, that it may naturally sort of come out as far as if the court wishes. I think it's something that the court can cure by issuing a curative instruction if there's any prejudice to be suffered by the defendant. But again, it is a statement by the defendant, which is admissible, as the court is well aware. And then it is sort of in the confines or in the context of her being in custody when she makes that statement. I certainly wouldn't be trying to elicit testimony that she was in custody, but it is kind of apparent that she is.
Can you have that here for this afternoon?
Yes, I can arrange for that.
So we can see it?
Sure.
Now let's watch the police body cam to see what Karen said. It is a bit hard to hear, so you may have to adjust your sound.
Do you have that video all pulled up, Mr. Lally, for me to see?
Yes, Your Honor.
Okay.
And, Your Honor, for the record, it's a little bit lengthy as far as the entirety of the video. The portion that I would be submitting to the court is from 7 minutes and 4 seconds until 9 minutes and 55 seconds.
Okay. Can we? Thank you.
So we locked up the house. The back door, we just did the lock.
Okay. Can you explain to me what the process is right now?
Absolutely. So you're going to be booked just like last time. Go through the same process. It's going to be a little less time consuming because we're not going to do major case prints because we did those last time. Once you're booked and you go through this portion of it, we'll let you make a phone call just like last time. We'll make a phone call. Your parents will be able to bring you whatever other additional need, things that you need.
Yeah.
And then tomorrow morning, you'll go and be arraigned at Norfolk Superior Court on the charges that were. I'm sure you'll go over the charges again with you on the warrant.
But I'm on bail, so how can I be spending the night here again?
All right, so I'll explain that portion to you, as long as it's not going to interfere with you. Are you ready to go?
Yeah, I'm just waiting for Ram to.
Okay. So, initially, your arrest was on probable cause out of the district court, okay? So the charges that you were arrested on initially were out of district court, out of Stoughton District. That's where the arraignment was. It was district level charges. Today, grand jury indicted you on these charges, which is second-degree murder, vehicular homicide, and leaving the scene of a death, okay? So those are the charges that grand jury indicted you on. So now you're being charged and will be arraigned in Superior Court, Norfolk County Superior Court in Devon. Okay?
So bail doesn't apply anymore?
Typically, I'm not, so we don't set the bail. But typically, once murder comes into play, people don't get bailed out.
So it's not manslaughter anymore, is that the difference?
That's correct. It's a higher degree of taking a life. Okay? So that's the charges that you're being charged with now. And you were indicted by grand jury.
Okay, you're aware he was beaten up by Brian Albert. I mean, we're all in on the same joke, right? My taillight was cracked and John was pulverized.
Okay, you need to abide by the rights that were afforded to you, okay? So you can talk if you want. If you want to tell us what happened, that's fine, we'll listen, but you were ready to do your rights, okay? And I'm sure he's gonna do it again. All right, if you want to talk to us, you want to give us a story, definitely. But we'll take it.
No, I mean, I know you already know the story, so I don't need to.
Did you catch what he said, she said, and what she actually said? Now I'm going to play both clips in succession, but a bit slower, so see if you can catch the deception.
Me an idea now? Do you know the substance?
So the substance of these particular statements is the defendant, Ms. Reed, continuously is told by Sergeant Bukhenik to essentially stop talking. He's advised her of her Miranda and advised her to stop making statements, and repeatedly states that to her during the course of her making statements. But the sum and substance of it is she says something to the effect of, you know, are you in on the joke? And then makes some sort of reference to having witnessed Brian Albert and Colin Albert essentially smashed John Okeefe's head into the taillight, indicating that that's how her taillight was broken. Doesn't make any sort of further statements about why she would then leave the scene after that occurred or anything like that.
Okay, so that's the charges that you're being charged with now. And you were indicted by grand jury.
Okay, you're aware he was beaten up by Brian Albert. I mean, we're all in on the same joke, right? My taillight was cracked and John was pulverized.
Okay, you need to abide by the rights that were afforded to you, okay? So you can talk if you want. If you want to tell us what happened, that's fine, we'll listen, but you were ready to do your rights, okay? And I'm sure he's gonna do it again. All right, if you want to talk to us, you want to give us a story, definitely. But we'll take it.
No, I mean, I know you already know the story, so I don't need to.
All right.
So he is saying that Karen Reed said she witnessed Brian Albert and Colin Albert smash John Okeefe's head into the taillight, inferring that is how her taillight was broken. And what she actually said was, you are aware he was beaten up by Brian and Colin Albert. I mean, we are all in on the same joke, right? My taillight is cracked and John is pulverized. She did not say she saw Brian Albert and Colin Albert smash John Okeefe's head into her taillight. What I hear is that she is pointing out Her cracked taillight is minuscule compared to what happened to John. And in her first trial, the defense focused on someone setting her up with, all the broken taillights, pieces that were found over a long period of time, and the lack of investigating the possibility of a third party causing John Okeefe's death. What did you understand Karen Reid to say? Can you see the deception in the prosecutor's interpretation? There is a factual lie, and there is an inference that did not take into the tone and innuendo that Karen Reid had spoken with. Now, I was concerned about what the prosecutor was trying to do, but then I found another concern. But first, let me tell you what I was first concerned about. So the prosecutor wanted to play the police cam footage for the jury because he very clearly said Karen Reid made incriminating statements after being told her Miranda rights. He said Karen Reid saw Brian and Colin Albert smash John Okeefe's head into her taillight, and then she left the scene. We heard that she did not say that at all, but before they played the police body cam footage, the judge gave the defense the opportunity to give their position. Here, let's have a listen.
Yes, I can arrange for that.
So we can see it?
Sure.
All right, what's the defendant's position here?
We object. Your Honor, we're in a situation now where the Commonwealth arrested Ms. Reid twice when they didn't have to. I made the argument to you at arraignment back in June of 2022 that after John Okeefe was found dead on the lawn of Brian Albert's home, I immediately got a letter out to the state police saying, I represent her, I will surrender her, no need to arrest her, just call me and I'll bring her in. They ignored that and they arrested her to get her into custody. I would assert ultimately to make the arguments that Mr. Lally is making today. Then, astonishingly to me, after the grand jury issued indictments, based on basically no new evidence, they upcharged her and once again did not contact me, despite the fact that she was completely in compliance with the terms of her release and had made every court appearance. They arrested her again. And so, again, I would assert to be in the position that they are in today. With regard to the case that they cited, Your Honor, Hoffer does not stand for the proposition that they claim that it does. In fact, the issue of that defendant being taken into custody was stricken by the court. The testimony in that case that was allowed or sanctioned by the SJC was evidence that the defendant had been living with his girlfriend but had unexplained absences. He didn't get along with her son. She was afraid of him, and that he associated with a convict that made her nervous. There was nothing about him being in custody that was admitted in that case. To the extent that these statements are, or the court deems these statements to be relevant and admissible, there are other ways to do it. I do urge the court to watch the video.
Yeah, I think we'll put it on the screen because I want to see how the jury would look at it.
Okay, that's fine. But I will suggest, Your Honor, that there are other ways to accomplish that, either to have testimony about what it was, or failing that, to have the audio of my client making whatever statements they seek to introduce without the video. An image of my client, in handcuffs at a police station is what this court generally tries to avoid, given the fact that as she sits here and as this trial is ongoing, she's presumed to be innocent. We wouldn't bring her up here in an orange jumpsuit and then ask the jury to make decisions about her, nor should we display her, after a perp walk at the police station in handcuffs, making these statements.
All right.
So we just heard the defense's response, and the team focused on the look it would give the jury if they were to see the police body cam footage. They were also concerned if the state said she was in custody and in handcuffs. And an option would be to have testimony about what she said. Now, this is what really concerned me. Why would they offer this? Imagine if the officer testifying gave the same testimony to the deceptive version that we just heard the prosecutor Lally give. Can you imagine? I wondered if they hadn't picked up on what the prosecutor had alleged. She said, so that, they do go on to say that they could introduce what was said on the police body cam footage by audio only. Can you guess what the judge decided? Well, the judge ultimately decided to allow audio only at the first trial, and the jury only heard the exact part that I played for you, in slow speed. So I did have some ethical concerns on how the prosecutor interpreted what Karen Reid had said. Now, had he said what was completely out of context and deceptive to the judge, had he said this in the trial to the jury, I would imagine that would have been prosecutorial misconduct. Imagine if the judge didn't watch the police body cam footage and accepted what the prosecutor had said to be true and ruled that she would allow testimony in. Allow testimony only. So, there's this phrase that once heard, you can't unhear something. And that's the problem I have with allowing testimony that isn't correct. So there was a benefit to having the police body cam, as it clearly dispelled what the prosecutor had said she had said. Now, I have a strong feeling the prosecutor has been relying on what he is being told by others. Had he even seen the body cam footage beforehand? And I'll tell you why I think this, because a similar thing happened, and I'll explain that in just a second. So when I say a similar situation happened, when the prosecutor, Adam Lally, was questioning Jen McCabe in the first trial, he elicited testimony from her that the visual evidence contradicted what she was saying. When he realized what he had done, well, first, let me tell you in a nutshell a bit of the background. So Jen McCabe, you can see her on the screen. I did a video about it, so it's in the playlist. So Jen McCabe told a lie about when she saw the damaged taillight on Karen Reid's car. And the door cam video taken from the victim, John Okeefe's house, exposed this lie. So back to Adam Lally. To then keep the second witness that allegedly saw the broken taillight, when she came up to give testimony, to keep her from lying, Prosecutor Lally manipulated the way he presented the evidence and questioned this other witness differently so that she wouldn't get caught out in the same lie. I have never seen such manipulation, you guys, so you've got to check out that video. It's just unbelievable. Now let's look at the recent motion hearings in preparation for the retrial of Karen Reid, as the prosecutor, Adam Lally, wasn't the only one to spew deception in front of the court. The new Special Prosecutor Hank Brennan appears to be playing the same deceptive games. He told the judge in this pre-trial motion hearing that Karen Reid called her parents before finding John Okeefe, yet her call logs did not support this. Here, let's have a listen to that exchange.
Requested records of Mr. Reed. I'll hear you, Mr. Brennan.
The Commonwealth has filed a Rule 17 motion to obtain phone records from William Reed for a 24-hour period. Secondly, the Commonwealth in that motion is looking for records regarding call logs for a 30-day period for William Reed. Although a different motion similarly, the Commonwealth has filed motions simply for the call log for 30 days for Janet Reed. The Commonwealth has a burden with two of these charges, one being second-degree murder, to show the element of knowledge. It is the government's burden to show that Ms. Reed knew she struck John Okeefe. Second-degree murder, as the court is aware, is a person committing an intentional act with a strong, plain likelihood of death. In a second-degree murder charge, there are a number of different theories that a Commonwealth can progress. It could be an intention to hit somebody, or it could be that somebody intentionally drove, struck somebody, left them behind, and didn't render aid knowing that there's a strong potential likelihood of death. When Ms. Reed knew that she struck John Okeefe is a critical issue in this case. Simply because the government has significant evidence outside of phone records to support and to convince that Ms. Reed knew she hit John Okeefe when she did, the government's entitled to the full value of their proof. The records for 30 days begin with that aspect of William Reed's records. Ms. Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John Okeefe. She called both of them, and those calls were unanswered, according to the phone records. The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, the inference is strong evidence that Ms. Reed knew she had done something terrible. She knew she had struck John Okeefe, and she knew that she had left him behind. The 30-day period is an attempt to protect the privacy rights of William and Janet Reed by not asking for the call, the text messages, not asking for SMS messages, not looking to forensically download the phone, just the call records, because I expect it will establish that there are no other calls in that 30-day period from Ms. Reed to her parents at 1:30 in the morning.
But can't you get that from Ms. Reed's phone?
No. No. There were 2 search warrants on Ms. Reed's phone.
I can't read them. The search warrant that was attached that I have isn't clear, so I'll need clear copies of those search warrants.
Those are provided by the defense. I can provide clear copies.
Okay, to speed this up, I'm just going to let you know what he goes on to say. He's just said that he doesn't have the previous 30-day records before the alleged incident, and now they want to argue that medical treatment, if rendered within the first couple of hours, could have saved John Okeefe's life. He goes on to say that he wants 24 hours download of Mr. Reed's, Karen's dad's phone. Let's listen to that.
The 24-hour phone records will show Mr. Reed's phone calls throughout that evening or that morning. And it's important because Mr. Reed had an opportunity to speak publicly, and he did so on Fox 25, which is the subject of another motion. And when he speaks to Fox 25, he gives what I see as an implied admission that his daughter told him that she had hit something. I think there's more to that story that will be explored at trial. The time of the phone calls to Ms. Reed are important. They're reflected in her phone records in the morning that she speaks to her father while she's still in the back of a police car before she's brought to the hospital. In that discussion with Fox 25, the quote is, "In your first discussions," my motion leaves off the S in discussion, but it's in the first discussions, what did she tell you? Mr. Reed asserts that she tells him about this implied confession at the hospital, which is after the actual first conversation. And so it will be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can denounce or deny his daughter's phone records. He doesn't have to accept them as true. Also, in that first 24-hour period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of a stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e., Mr. Okeefe, is critical to the government's case. And so we cannot rely just on Ms. Reed's phone for a couple of reasons. Number one, phone records often show different communications. Sometimes calls or hang-ups don't register on a phone, and so they could be different. Secondly, I've learned that Ms. Reed's phone was sent to a taint team, and the Commonwealth does not and should not know what, if anything, was redacted from Ms. Reed's records. The idea of sending it to a taint team, I surmise, is that something was viewed that determined that it should go to a taint team, or perhaps the defense raised the issue. I don't have the benefit of the history. But what I do know is we cannot say that the records from Ms. Reed are a full accounting for records, and so that Mr. Reed's records stand separately from Ms. Reed's records. Those are the two different types of records I am requesting from William Reed. I've been careful to make it limited. I'm not looking to see their physical phone. I'm not looking for a forensic download. After the first day of Mr. Reed's records, all I am looking for is call subscriber information in phone registers. I note the defense point of collateral information. I don't even want to see it. I just want to see if there's communication between Ms. Reed and her parents, so that if we present that inference, it is a sound inference, it is a fair inference, and it is a solid inference. And that's my argument regarding the phone records of Mr. Reed.
All right, who's arguing this for the defense?
Thank you, Your Honor.
Whoa, the prosecutor is really forcing the defense to spend a great deal of time focusing on clearing up and cleaning up the state's factual deceptions. So we're going to hear about that in a second. And we saw it in the first part of this video I did, when there's factual evidence that the state is trying to, bring forward so that they can get evidence allowed in. It's really important for the defense to clean that up. So we're going to hear now that they've kind of, cottoned on to what the prosecution is capable of. And they want to make inferences, the prosecution, which is fine, as to, what they believe it means. However, we did see as well in the first part of the video, they're not always making the right inferences. So before we go too far down the rabbit hole, that Karen Reed was frantically calling her mom and dad before she found John unresponsive on the Albert's front lawn, let's listen to the defense's response.
That's my argument regarding the phone records of Mr. Reed.
All right, who's arguing this for the defense?
Thank you, Your Honor.
Your Honor, the defense requests that the Commonwealth's Rule 17 motion seeking Ms. Reed's father's private cell phone information be denied. The Commonwealth is seeking 3 categories of information for Mr. Reed's cell phone: his private subscriber information, all call records, call detail records, SMS, MMS, and all data use records from January 29th and January 30th, 2022, and finally, all call detail records for an entire month-long period spanning December 30th, 2021 until January 30th, 2022. Your Honor, we are 3 years into this litigation, and the Commonwealth is now seeking to invade Mr. Reed's privacy under the guise that it's seeking communications between Mr. Reed and his daughter. But the Commonwealth already has a record of all of the communications between Mr. Reed and his daughter on January 29th, from not one, but 2 separate sources. The Commonwealth is in possession of Ms. Reed's cell phone. It's also in possession of Ms. Reed's Verizon records. The Commonwealth is asking this court to sanction this gross invasion of her father's privacy so that the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. Now, I know Mr. Brennan says, I'm not interested in seeing anything else. But the problem is, that's not what his motion says, right? He's asking for every single call, regardless of recipient, for a month-long period. William Reed has never been called by the Commonwealth to testify as a witness in this case.
So this is a new trial, right? So that doesn't
Right.
prohibit the Commonwealth from calling him.
I understand, Your Honor.
Okay.
He wasn't present at 34 Fairview, he wasn't present at CF McCarthy's, and he wasn't present at the waterfall on January 29th, 2022. And I would note that this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone.
So I've paused it there for just a second. The defense has got kind of 2 points that they're trying to make. And the first one is that the state has requested a motion that misrepresents what they put in writing. Okay, and the second part of what is going on, and there's a little history behind this part, is the defense is reminding the court of her prior rulings not allowing the phone records in from the others that were out with the victim and at the Albert's house, where the victim, and don't forget, we can't forget the victim, John Okeefe, was found. But clever Judge Cannoni cut this attorney off because she knew where she was going and said, this is a new trial. So in the previous hearing, after the defense had requested the phone dumps from those that were at the Alberts property where John Okeefe was found. Well, for some reason, most of them had already gotten new phones or had destroyed their old ones within days of the defense filing the request. So it begs to wonder if they had a heads up.
But this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone, using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night. The Commonwealth, again, is already in possession of Ms. Reed's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Reed did not make any calls to her father on January 29th until after she discovered Mr. Okeefe lying incapacitated on Brian Albert's front lawn. And I've attached a copy of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th after she discovered Mr. Okeefe lying incapacitated on Brian Albert's front lawn. And I've attached a copy of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th. That was at 6:32 a.m. The Commonwealth has a copy of those records. It's in their possession. And as this court knows, Lampron explicitly requires that any Rule 17 motion must be accompanied by an affidavit containing a factual showing that all four elements of Lampron were met. Here, the Commonwealth has failed to meet its burden, to meet even a single prong of that four-part test. In regards to the burden that they have to establish that the records are evidentiary and relevant, the Commonwealth in its affidavit set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his phone records. And I would note, the Commonwealth's characterization of that interview is incorrect and incomplete. I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, "I believe I hit something," was the Chevy Traverse, which the court knows. We have a video of her hitting a Chevy Traverse that morning. The Commonwealth is already in possession of Ms. Reed's communications from January 29th. Those were included in the Commonwealth's motion itself. And the Commonwealth has failed to explain why it believes additional relevant communications will be found in the call detail and text records. That was not included in the affidavit. The Commonwealth states they expect to substantively admit the phone records between Ms. Reed and her father to prove that the 6:32 a.m. call took place. But they can do that with the phone records that they already have. Just because they have records from Verizon, that doesn't establish who answered the phone. That's not something that they're going to get from Verizon. The Commonwealth is well aware of that fact because they have Ms. Reed's cell phone and her Verizon records, so they can confirm that there's only one call on the morning of January 29th. The Commonwealth has provided no factual basis whatsoever to suggest that there are relevant communications that will be found on January 30th, the day after this incident. And the Commonwealth also requests that Ms. Reed's phone records for the full month preceding January 29, 2022 is necessary to show that it would be unusual for Karen to have called her father. And the Commonwealth did a kind of funny thing, right? They suggested during their arguments that she called both parents in the middle of the night. That's not true. There was only one call to her father on January 29th, the morning of. It was at 6:32 a.m. So the frequency at which Ms. Reed called her father's cell phone in the middle of the night has no relevance whatsoever. As to the second element of Lampron, here the Commonwealth's affidavit is facially deficient. It doesn't even reference this element or set forth any facts supporting that it's shown that the Commonwealth's records are not otherwise procurable reasonably in advance of trial. And the reason Mr. Brennan cannot in good faith make that statement under oath is because the Commonwealth is already in possession of these communications from two separate sources. Element 3 of Lampron was also not addressed in the Commonwealth's affidavit. It's facially deficient. The Commonwealth has failed to show that it cannot properly prepare for trial without the production of this evidence, and that the failure to obtain the evidence would unreasonably delay trial. Again, that's because the Commonwealth is already in possession of the evidence that they're requesting. Finally, the Commonwealth has also failed to show that this request is made in good faith and is not a fishing expedition. In its affidavit, the Commonwealth briefly addresses the fourth element of Lampron, but writes only, quote, "The Commonwealth's motion is not a fishing expedition, as it is evidence from the defendant's phone records that phone calls between defendant and Mr. Reed were made sometime after defendant struck the victim and before the victim was found." Your Honor, that statement is provably false. Ms. Reed's phone records established conclusively that she did not call her father on January 29th until 6:32 a.m. after she found her boyfriend incapacitated on Brian Albert's front lawn. Therefore, the requested records should not be turned over to the Commonwealth. This is a broad request to review a month's worth of Mr. Reed's private cell phone information and all of his data usage information from January 29th and January 30th. This is a fishing expedition, plain and simple. The Commonwealth isn't asking for the records it already has. It doesn't need a third copy of them. What it's looking to do is sift through Mr. Reed's personal cell phone information on January 29th to see if it can find data usage information, location information, text messages with other individuals, and that is a completely inappropriate use of Rule 17. This unsupported request is overbroad and must be denied. Thank you.
All right, thank you. Did you want to respond in any way, Mr. Brennan, or move on?
Very briefly.
Okay.
In between the multiple accusations of bad faith, what the attorney says that is most telling is they don't know who answered the phone. That's a harbinger to trial. The prosecution doesn't know who answered the phone when Karen Reed called her parents or her mother's phone at 1:43 a.m. No, the Commonwealth doesn't. And so we have to prepare that when Mr. Reed takes the stand, we have phone records demonstrating all of his phone calls and that he had control of that phone, so there can't be a suggestion somebody else was handling the phone. Or, on the other hand, if the position is going to be that Janet Reed answered the phone, the father's phone, or that William Reed answered the mother's phone, then we'll call both witnesses at trial and we'll sort it out. But it is that very nature of suggesting confusion or uncertainty that the government is obligated to try to prevent that trial. And we're being diligent, we're being studious, and we're going to be prepared. And these records will help us do that. That is the exact point and reason why we need these records. Thank you.
All right, did you want to respond at all, Ms. Little?
Well, I think the Commonwealth actually brought up the issue of, it tried to basically say, I need the Verizon records because Karen's phone records don't establish that Mr. Reed answered the phone. But all I'm saying is that neither do the Verizon records. So there is no additional information the Commonwealth is going to obtain by digging through Mr. Reed's private cell phone information.
Okay. All right, so we sort of overlapped a little bit with Mrs. Reed, Janet Reed's records. Do you want to be heard further on that, Mr. Brennan?
No, I believe the court understands my argument unless the court has any questions for me.
I don't, but thank you. Ms. Little, is there anything specific to Mrs. Reed that you want to address?
Yes, Your Honor. Again, I just emphasize that the affidavit in support of their request for Ms. Reed's phone records is plainly insufficient. They haven't addressed numerous elements of land prom. That alone is a basis to deny the request, and it's not permissive. It's mandatory that the court deny the request. Land prom is very clear. If you don't meet a factual showing in the affidavit in support of your Rule 17 motion, then the motion must be denied. 3 of the elements were not even addressed in that motion. So on that basis, we request that the court deny the motion.
Okay. Thank you.
Well, what did you think of that? That was some sort of reply from the defense. Deception is the act of deliberately causing somebody to accept something as true that is not true. In the examples we examined, we saw with our own eyes both prosecutors, Mr. Lally and Mr. Brennan, told bold-faced lies. The question I have is why? Are they hoping we will believe them because they represent authority? I kind of like the idea of the comparison to Santa Claus, because when we are little, we believe what we are told. But at a certain age, we start to question the truth. We look for evidence, and when we are analyzing these cases, we expect people in authoritative positions to be ethical and tell the truth, so the right offender is held accountable. And when we don't look for evidence to support what is being told to us, innocent people are convicted. Well, thank you for watching, and don't forget to hit the subscribe and the like and do all those kind of things. I mean, heck, it's free. You can do it for free, so why not? By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.